Arbitration is the contractually mandated dispute resolution process that serves as the sole mechanism in place for Amazon sellers to raise legal disputes with Amazon. When anyone creates an Amazon seller account, they must agree to be bound by a contract called Amazon's Business Solutions Agreement, or the BSA. This contract contains what's referred to as a binding arbitration clause, meaning that sellers forfeit their right to sue Amazon in a traditional litigation setting the moment they create their Amazon seller account. What's up, sellers? My name is Rob Siegel, managing the arbitration and brand protection practices. If this is your first time on the channel and you enjoy this video, please make sure to hit that like button and subscribe to stay up to date on all of our content. Today, in this video, we're going to talk about arbitration cases against Amazon, the most common reasons sellers arbitrate against Amazon, and some of the benefits of arbitration in comparison to adjudicating disputes in a traditional litigation setting. So without further ado, let's take a deeper look at Amazon seller arbitration and what sellers need to know about it. First, let's talk about what arbitration is. We already said that arbitration is a dispute resolution process and that sellers are forced to resolve legal disputes via arbitration due to the BSA clause, but what exactly does going to arbitration look like for the Amazon seller? Simply put, arbitration can be described as casual court. That means an award in arbitration has the same legal effect as a judgment in a courtroom, but the arbitration process is much more simplified than traditional litigation. For example, an arbitration hearing would usually occur in a conference room instead of a courtroom. That said, arbitration still has the ability for sellers to utilize legal tools such as the discovery process and motion practice, but most of the arbitration process can be handled electronically, and hearings, especially in light of the real-world situations going on right now, are often conducted by video. The main difference between arbitration and litigation, though, is the lack of legal precedent. This means that in arbitration, arbitrators are free to make their decisions in each case without consideration of how previous cases were decided by other arbitrators. While some may view this as a disadvantage for sellers, it actually does ensure that each case is decided on an individual and fact-specific basis, and arbitrators can still be influenced by decisions that are made public in other cases through things like press releases. At the end of the day, sellers don't have a choice whether to arbitrate their disputes or not, and must arbitrate their disputes with Amazon if they have one. So let us know what you think about Amazon's forced arbitration in the comments below. But now that we know what arbitration is, what are some of the most common reasons sellers arbitrate against Amazon in the first place? Today I'm going to discuss the 5 most common case types we see sellers take to arbitration, but literally any dispute can be arbitrated when the appeal process fails and it is clear that Amazon is making an error no matter what the seller communicates. That said, number 1 most common case we've been taking to arbitration lately is lost or destroyed inventory cases. It's often difficult to deal with the slow response times or the lack of responses from the FBA team whatsoever, so lost and improperly destroyed inventory cases are usually good to bring to arbitration. Also, cases where funds are withheld improperly by Amazon, for example, if there's false allegations of inauthentic product sales, those cases are almost always resolved in arbitration when we demonstrate that our client's supply chains are perfect and linked back to the manufacturer. Next type of case we see often reach the stages of arbitration is listing hijacking and manipulation issues. This could be when a third-party seller is engaging in bad activity and taking action against the competitor's listings by doing things such as changing the brand name or altering the listing descriptions, or even changing the photos to inappropriate or unrelated products. Number 4 are hacked seller or brand registry accounts. Well, obviously account security is really important, so if you ever have an issue where your account is hacked or your brand registry access is compromised, it might be a good idea to get Amazon legal attention and go right to the arbitration process to make sure your funds and your identity are protected. And last, although these disputes are not governed by the BSA and there's a separate agreement for vendors, we also have a ton of experience arbitrating Vendor Central related disputes, regardless of what the issue is. Vendor Central does not have the full-fledged appeal process like sellers do on the Seller Central platform, so oftentimes vendor disputes or vendor issues can go right to arbitration if the case is the right fit. Again, these are just a handful of some of the reasons sellers arbitrate against Amazon, but any and many cases could be ripe to go to arbitration. The best cases, though, involve situations where Amazon has clearly made a decision in error and sellers have exhausted all appeal options Amazon has in place to resolve the dispute that they're having. If you do have a specific question about a potential arbitration case, feel free to reach out to us at any time at the contact information below. Initial consultations are done as a courtesy, and we love to help sellers fight back against Amazon's erroneous decisions and mistakes. Finally, I did not want to end this video without discussing the benefits of arbitration. Although forced arbitration is often criticized, the arbitration process does provide a unique opportunity for sellers to bring their issues to the highest level of attention at Amazon possible. Like I said, the best cases are those in which Amazon has clearly made a mistake and failed to correct that mistake when a seller put them on notice of it. In many cases, simply bringing these true facts and the information to this higher level of attention and Amazon's third-party legal team often results in resolutions and early settlements in the arbitration process. Also, our firm has filed hundreds of arbitrations over the years, and our unique experience helps us identify trends, how Amazon's counsel operates, and the best way, at the end of the day, to help sellers resolve their issues and get back to selling. Arbitration is a last resort for Amazon sellers and should never, ever be considered until the appeal and escalation processes are fully exhausted for the issues at hand. That said, arbitration is a great way to take the decision out of Amazon's hands when their mechanisms fail to address your seller issues. If you'd like to know more about arbitration, please let us know in the comments below and be sure to tell us what topics you'd like to see addressed on our channel. As always, if you like this video, please make sure to like and subscribe, and feel free to contact our team day or night if you want to discuss a potential arbitration case with us. Our contact information is right below or in the description for further details. Thank you.